you have one of the largest censorship systems in our history, if not the largest. It's been called Orwellian by lower court judges. And what the court is saying is that we won't hear you on this issue because you're not the right litigants.
All right, so today the Supreme Court came down with one of the big decisions we've been waiting for. Not the biggest one. The biggest one has to do with immunity and the lawfare persecution of Donald Trump. But this was a big one. This involved the government putting pressure on social media companies to censor and silence individual Americans expressing their opinion. In some cases, their very correct opinion and facts about COVID-19, about the virus, about the vaccine and its effectiveness. And yes, the Biden administration and the government, through its agencies, put pressure on social media companies to clean up that mess and delete people's ideas. Well, this made it all the way to the Supreme Court. And, well, let's just remind everybody before we get into the details of the decision what the First Amendment actually says. Congress shall make no law. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Right? That's pretty simple. That's pretty easy to understand, although, boy, if you're from the left, that seems to get confusing as well. And then there's this, or abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances. So if you take some of the semicolons out of the way, because this doesn't have to do with the right of the people to peaceably assemble or to petition the government or redress of grievances, if you just take the freedom of speech part of it, the First Amendment clearly states that Congress shall make no law respecting an establishment. Oh, excuse me. Let me start that again. Congress shall make no law abridging the freedom of speech, right? If you take the religion part out and it's just the what does the First Amendment say about the freedom of speech? Congress shall make no law abridging the freedom of speech. And obviously, the executive branch of government, which is where the White House, the Biden, the presidency, the FBI, Justice Department, all those guys, they only operate if Congress establishes their agencies and funds their agencies. So anything that those agencies do, they do it with Congress's establishment and permission, right? We're clear on that. So if one of those agencies abridges the freedom of speech of an American citizen, well, they've operated outside of the Constitution. That seems pretty simple. But if you're on the Supreme Court, it's not. Because they came down with their ruling today, that really crazy right-wing, out of control Supreme Court that needs to be completely blown up and stacked and fired because they rule on things like abortion that left-wingers don't like. Well, today they love this Supreme Court because it gave them the power to silence you if they don't like your opinion. Sort of. Here's how Jonathan Turley on Fox News laid it out.
Jonathan Turley, the First Amendment, obviously you call yourself a free speech absolutist. What does this mean? If the states don't have standing, who does?
Well, it's very frustrating for the free speech community because standing is often used to block meritorious claims. This is one of the most fundamental issues that we are facing. I wrote about this issue, this case in my recent book, because you have one of the largest censorship systems in our history, if not the largest. It's been called Orwellian by lower court judges. And what the court is saying is that we won't hear you on this issue because you're not the right litigants. Now, I have to admit, I've always been something of a standing dove. I believe that these standing decisions are too narrow because they do prevent the court from rendering a decision on such important constitutional questions. So this issue will have to wait for another day. But one of the things that many of us have been arguing for years is that the government is engaging in censorship by surrogate. I testified about this in Congress, that they have made a mockery of the limits of the First Amendment by doing indirectly what they're barred from doing directly.
Yeah, so let's spell that out for you. By the way, what is this phrase he just used? The First Amendment community? Aren't all American citizens part of the First Amendment community? Or shouldn't you be? Who isn't in the First Amendment community? Yeah, I'm not going to hang with those guys. They're way too First Amendment-y for me. First Amendment is for all of us. It protects everything that we do. And as you just heard Jonathan Turley say, the Supreme Court, by not ruling today on this, they basically given permission to the federal government to censor any American citizens they disagree with by proxy. They don't directly do it. No. But they indirectly do it. They compel other people to do it on their behalf. It's like, oh, no, I'm not guilty of murder. I just hired someone else to pull the trigger. No, you'd still be guilty of murder. And that's kind of what happened here. Now, let me first start by giving you some of the good news, because it's not good news, but there's a glimmer of hope in this decision today. And that is what you just heard Jonathan Turley discussing, that they didn't actually make this decision on the merits. All right. They didn't look at the facts involved here and say, yes, of course it's okay for the government to do this. You betcha. It's okay for the government to demand meetings through the FBI with Twitter or Facebook or Instagram or whoever else is out there, whatever platform that you're using to express your opinion. It's fine for the FBI to pick up the phone and say, hey, that's a real nice social media platform there. It would be a shame if anything happened to it. So why don't you silence and censor these accounts for saying things we, the government, don't like? Otherwise, it's going to be big trouble for Twitter and Facebook. See, that's what they did here. And the Supreme Court thankfully did not say, you bet your butt it's fine for the FBI to do that. They didn't do that. They came this close to doing it. If they had done that, then they would have made their decision based on the actual merits of this case, and they did not. What they decided here is that the people who were arguing here to the Supreme Court about this issue, that they didn't have standing to make the argument, that they weren't actually directly harmed by the government's actions. Therefore, the case that was in front of them had no merit, and that's what they decided. It's bad, but it could have been a lot worse. All right, so now let's get some analysis on this, because I know you're going to find this shocking. Not only am I not a lawyer, I'm not a constitutional lawyer, but you know what? I'm an American citizen. And the fact is, our founding fathers, unlike lawmakers today, who can't, write a law that says that you shouldn't murder somebody without making it a 10,000 page, 8 million word law. The founding fathers actually took great pains to make our founding documents succinct, concise, and comprehensible. It shows their genius. Anytime I get a Martin Scorsese movie right now and it's 6 hours long, I think, yeah, he's losing something. Because it takes a real genius to be able to say something powerful and true and comprehensible and understandable in as little time as possible. The greatest writers are the ones who were able to eliminate all the words that are not necessary. Our founding fathers were geniuses because they made the Constitution, now 250 years old almost, completely understandable to anyone. You don't have to have a law degree to understand it. You don't have to be a constitutional expert to understand it. In fact, you've got to have a law degree to screw it up, which is what we often see. So let's turn to some people who have analyzed this. Now, Dr. J. Bhattacharya, I'm terrible at his name, and I'm sorry, Dr. J. Dr. J, I wonder if he plays basketball. Dr. J. Bhattacharya is not a legal expert. He's, in fact, a medical doctor and an expert on viruses. See, he has a vested interest in this case and knows a lot about it because he's one of the people who was silenced by this. All right. And he says losing on the standing argument means that the Supreme Court thinks the government, as long as it doesn't specifically censor a person, can censor ideas without violating the First Amendment. You get that? As long as they're not censoring you, an individual, we're just censoring an idea. Well, that's okay, because an idea is not protected by the First Amendment. The Constitution isn't there to protect ideas. The Constitution's there to protect citizens. And boy, you've got to twist yourself into a pretzel to really get there. But that's kind of what they did. Now, let's expand further on Dr. J. Bhattacharya here. Because again, he does have standing. He was harmed by Twitter. He was expressing, as a Stanford medical professor, somebody with exquisite, impeccable credentials, he was expressing an alternative opinion about COVID and the vaccines and such than what the government wanted you to hear. And the White House sent its army of goons from the FBI to tell Twitter to delete what he was saying and to stop him because it ran contrary to the government's line on COVID. Now, if that doesn't terrify you, there's something wrong with you. I guess you're not part of the First Amendment community. That's what happened to this man. And again, the Supreme Court basically said, yeah, they didn't technically violate the Constitution. Now, what can be done about it next, we'll get to, okay? But here's what Dr. J has to say. I'll read. Supreme Court just ruled in the Murthy versus Missouri case that the Biden administration can coerce social media companies to censor and shadow ban people and posts it doesn't like. And here's where we get to the remedy. Congress will now need to act to enforce the Constitution since the Supreme Court won't. And I think that's an overall lesson for a lot of us. You know, a lot of us, sadly, especially we conservatives or we brand newly discovered conservatives. There's a lot of you out there who never thought you were a conservative, but you've seen what's happened in this country over the last 8 to 10 years. And you now are championing ideas that conservatives have been sort of talking about for decades now, right? You may not think of yourself as a conservative, but guess what? If you're not on the left, you're one of us. Welcome to the party, pal. And a lot of us conservatives, we have fallen into the trap that the left created. You see, some of the worst ideas in our country have not been enacted by Congress over the last 50 years. They've been sort of insinuated into our government and into our society by court rulings. The left could never really get the popular vote or the type of electoral mass that they needed, critical mass they needed to have an overwhelming majority in legislatures at the state level or at the federal level to pass the kind of laws they wanted to fundamentally change our country. So because they couldn't do that, because the people weren't on their side, because their ideas were so bad, what they did instead was they used lawfare. What they did was they had a president, when they had Obama or Clinton in the White House, to appoint certain types of federal judges that then would see cases that would either reach judicial fiat through the federal court system and the Supreme Court when they had a majority there, or through forcing settlements with companies like the cigarette companies. The cigarette companies, they wanted to outlaw cigarettes. They've always wanted to outlaw cigarettes, but they can't because we have these stupid freedoms. So what did they do? They sued the cigarette companies, and they wasted the cigarette companies billions of dollars in legal fees in the court system until they finally relented and they said, fine, let's just reach a settlement. We're done with this. And so now there's these huge restrictions on cigarettes. There's a lot of things that cigarette companies can, and you may be in favor of that. That's not the point. It's how they got there that's the point. Now there's all these restrictions on cigarettes, on where you can smoke and how you can smoke and how cigarette companies can advertise for smoking and what kind of labels they have to have. And none of it was passed through law. It was all done through the court system, through settlements where the cigarette companies agreed to do this, just stay off our backs and stop suing us. They're trying to do that with gun manufacturers right now. They can't abridge the Second Amendment. So what are they trying to do? They're trying to sue gun manufacturers into oblivion until they reach settlements where they basically, acquiesce and do whatever the left wants. This is what the left has been doing. And sadly, we conservatives, we slipped into this pattern where we were relying on judges and Supreme Court justices and the judicial branch to basically give us the results that we wanted. And so Dr. J points out something that's really clear and really important here. Congress is now going to have to act to enforce the Constitution, and they can. They didn't. They should explain why they didn't. They may have thought, oh, well, we don't need to because the Constitution is clear here. Well, it's not. And the Supreme Court didn't do the heavy lifting for Republicans in Congress, so now it's time for them to do it. Dr. J continues. This now, and this is key for all of us this election year, this now also becomes a key issue in the upcoming election, which is good. We shouldn't have to sit and wait for judges to make these decisions for us. Every single person running for office should say, do you or do you not think that the FBI, acting on behalf of the White House, should be able to force social media companies to delete content that they don't like? Answer the question. In fact, this should be a debate question tomorrow. This now becomes a key issue in the upcoming election. Where do the presidential candidates stand on social media censorship? We know where Biden stands, since his lawyers argue that he has near monarchical power over social media speech. The court ruled that the plaintiffs, Missouri and Louisiana, as well as me, that would be Dr. J, and other blacklisted individuals, lacked standing to sue. This means that the administration can censor ideas, and no person will have standing to enforce the First Amendment. Free speech in America, for the moment, is dead. Really good, keen observations from somebody who was directly affected by all of this. Okay, Sean Davis, he's one of the founders of the Federalist. He had plenty to say about this too. Sean Davis says, the Supreme Court also appears to have created a brand new standard that appears nowhere in the First Amendment. Coercion. Yeah. See, get this. Look at, he's commenting on Jeff Clark's post here. The Supreme Court wrongly booted the most significant First Amendment case in U.S. history on standing of grounds today. And again, the whole idea is that the government never coerced speech or coerced these companies to silence free speech. But that's not what the Constitution says. It says nothing about coercion. The actual text in the Constitution sets the bar far lower. It's abridgment, not coercion, just abridgment. If you abridge free speech, if speech is abridged, the government has violated the Constitution, period. It's a sad day for the country and our rights as citizens to speak out against and hold our government accountable. And Sean Davis had one other point to make here. And he highlights this part of the prevailing decision here. And I'll read it, and then we'll get to his analysis. The plaintiffs cannot manufacture standing merely by inflicting harm on themselves based on their fears of hypothetical future harm that is not certainly impending. All right, what does that mean? Let's say you get a notification from Twitter that your account is suspended unless you delete a tweet that you've put up there, or you will be punished. Or let's say you have a YouTube account, right? And you've been doing videos about potential harms of the vaccine, and YouTube notifies you and they say you delete that video or your account will be suspended. And well, you count on the income that you get from YouTube, right? You pay your bills from YouTube because of the money that you make off of YouTube. And now you've got YouTube saying, you've got to delete this video. Otherwise, your account is suspended. No more income, no more livelihood for you. You won't be able to pay your rent. You won't be able to take care of your children. You won't be able to feed yourself unless you delete this video. And YouTube is only telling you this because the government put pressure on YouTube to do that. So, of course, you delete the video. That's called self-censorship. That's what the Supreme Court is saying. Manufacturers are merely by inflicting harm on themselves based on their fears of hypothetical future harm. You see that? Hey, the government didn't technically delete that. You just deleted it so you could keep your job. But, you know, you weren't harmed. You harmed yourself. You deleted it yourself. Here's Sean Davis's take. One of the most insidious intended effects of government censorship is self-censorship. By punishing others for what they say and believe, tyrannical governments terrorize their citizens' own thoughts by creating every incentive for them to just be quiet. But in its abominable opinion, effectively greenlighting government censorship, the Supreme Court explicitly mocked the mere concept of self-censorship and said it is little more than a citizen inflicting harm on himself for no reason. Citizens cannot manufacture standing merely by inflicting harm on themselves based on their fears of hypothetical future harm that is not certainly impending, the anti-free speech majority wrote in this opinion. This is not constitutional exegesis. It's the language of tyrants. He's correct. Which brings us back to what's the next steps? What can we do? Because yes, there is a ray of hope here. Because this decision was based on standing, then there could be another fight in the courts. That's what Attorney General of Missouri, Andrew Bailey, said. He's the one who brought this case in the first place. He says, my office filed suit against dozens of officials in the federal government to stop the biggest violation of the First Amendment in our nation's history. And by the way, it should be pointed out that every court leading up to the Supreme Court agreed with Attorney General Bailey and with the First Amendment. It won at every step along the way until it got to the Supreme Court. The record is clear. The deep state pressured and coerced social media companies to take down truthful speech simply because it was conservative. Today's ruling does not dispute that. My rallying, and it's true, by the way, that's another ray of hope. On the facts of the case that the federal government did this, the Supreme Court said, yeah, they did this. The only question is, are they allowed to? So there's no more denials from Karine Jean-Pierre, Jen Psaki, or Joe Biden. Oh, hey, we didn't do that. We were just letting them know. No. We know they did it. My rallying cry to disappointed Americans is this: Missouri is not done. We are going back to the district court to obtain more discovery in order to root out Joe Biden's vast censorship enterprise once and for all. Well, that's good, and I'm glad, and we want fighters on our side. But ultimately, this is about you. It's always about you. It's about us. It's about we, the people. First three words of that Constitution right before we get to the First Amendment. It's about us. It's about holding our elected officials accountable. No more hiding behind people in black robes. No more hoping that judges, that we find the right ones and it'll make its pathway up. No more counting on presidents who will appoint the next Supreme Court justice or waiting for the next one to retire or die so we can get another Supreme Court justice. No, this was 6-3, guys. No. This is about holding our elected officials accountable and making sure that anyone who wants your precious vote this November is on the side of freedom of speech and against the government compelling your speech to be abridged and completely shut down, because that's what happened here. And if we don't take a stand now, we're not going to have freedom of speech anymore. Kiss this show goodbye and anything else you like on the internet that may not exactly agree with Joe Biden or whatever other tyrant happens to sit in the Oval Office.